All right, you may be seated. President, case 25 CR 180, State of Ohio versus Lorenzo Robinson. We're here for evidentiary hearing on the defendant's motion to suppress defendant's here in court with counsel Mr. Corey Hinton. State of Ohio is present, represented by Assistant Prosecuting Attorney Ms. Taylor Linden. Are both sides prepared to proceed at this time, Ms. Linden?
Yes, Your Honor, thank you.
Mr. Hinton?
Yes, Your Honor, we're prepared.
Before we do proceed, I just want to get on the record whether there was any offers made in this case, and if so, what the defendant's position on that is, and also whether that offer is contingent on this hearing going forward or will be revoked if this hearing goes forward. I want to make sure everybody's on the same page with that before we go further here. Ms. Linden?
Thank you, Your Honor. Your Honor, we did
Hang on a second. You can, if you need to talk, go ahead and talk.
Okay.
No, I was asking. I was just telling him something. I forgot.
Well, go ahead and do it if you want. I just want to
May
make
we
sure.
have a quick moment?
Yeah, I just want to make sure you're listening, but do what you need to do.
Okay.
Ms. Linden?
Thank you, Your Honor. On April 8th of 2025, we did extend an offer, that being to plead to count 1, the weapons under disability, F3 with the forfeiture specification, and to count 3, the possession of cocaine with a forfeiture specification, indicating we would then dismiss the remaining counts, request a pre-sentence report and investigation, and drug and alcohol evaluation. So we did extend that offer. Following today's hearing, that offer would no longer be available. There has not been any kind of counter offer, and my understanding is that the defendant had rejected that offer when we were here last year, I believe, for a pretrial.
And as of right now, that's the current offer?
That is the current offer. There's been no counter offer, so that's the current offer right now.
That ain't what she said.
Mr. Hinton, you,
That's not what she said. That ain't what she said at all. But all right, go ahead. Do
you want to talk a moment to talk again?
Yeah, I think we're okay, Your Honor. We continue to reject that offer.
And you understand then that there'll be no offer made if this goes forward?
Yes.
You understand that, Mr. Robinson?
Yes.
So you heard what the offer was.
That was not the offer, bro, but okay.
What do you believe the offer was?
What I believe it was,
Yeah.
you hit me with at first you hit me with an F4 and an F5 weapons under disability, and then you hit me with an F3.
I didn't hit you with anything.
Not you, but I'm just saying in general.
There was an information offer originally, Your Honor, that was an
All right, so
F4
before this
and
case
F5.
went to the grand jury, they made an offer to plead by information to apparently an F4 and an F5, which you rejected at that time.
At a bond hearing.
He did file a motion to have his bond reconsidered.
Okay.
And
Before it went to grand jury?
Yes.
Okay.
And so
So at that
was
hearing,
accurate.
that offer was made and you rejected that at that time?
I rejected both of them.
Okay. So then the case went to the grand jury, and they are making a new offer now, which is not the same offer then, and you're rejecting that.
We're rejecting that one too.
Okay, that's fine. Yeah, I just want to make sure, and you understand that if this hearing goes forward, there will be no plea offer made. You have to either go to trial or plea the indictment if this hearing doesn't resolve the matter.
That's okay.
You understand that?
I sure do.
Okay, I just want to make sure that we're all on the same page before we go forward.
Okay.
Any questions about that?
Mm-mm.
Okay. All right.
And Your Honor, I did want to address this with Mr. Hinton. I know that this is just a clerical in nature. The indictment at the top says that there are 3 counts. There are actually 4 counts. So I would just ask that that be amended.
That's fine.
But other than that, we're ready to go forward. Thank you, Your Honor.
Mr. Hinton, anything you want to address before we go forward with the hearing?
No, Your Honor, not at this time.
All right, then I'll hear any opening comments from the prosecutor.
Thank you, Your Honor. Your Honor, in this matter, the defendant has indicated that he is challenging the stop and subsequent search that occurred on January 31st, 2025 in Painesville Lake County, Ohio, indicating that there was no probable cause or reasonable suspicion to stop the vehicle, nor was there any reason then to subsequently search the vehicle. The state anticipates today that based on the evidence that will be presented in the testimony of Officer McLeod, that in fact the officer did see the defendant in a vehicle, not knowing it was the defendant at that point in time. It was in the evening hours, it was dark out, and as the vehicle that the defendant was driving past, Officer McLeod saw the defendant with a mask over his face. At that point in time, didn't know if it was male, female, didn't know who it was. The individual then slumped down in their seat, and Officer McLeod then turned his vehicle around, ended up following the vehicle, ran the license plate, found that the registered owner of the vehicle actually had a suspended license. And as he had turned around and caught up to that vehicle, he then noted that there was an issue with the taillight and the fact that it was emitting a white light rather than a red light on the stoplight.
Who's in the courtroom here? Who's the staff here? And are there any potential witnesses in the courtroom?
Not for today's hearing. I know Ms. Reichard is a potential witness for the trial. In fact, she was served a subpoena by the state today, but she was not going to testify in today's hearing,
okay.
At least not for the defense.
Okay, good. That's why I want to make sure that.
No, I appreciate that. Thank you, Your Honor. And when Officer McLeod then noted this additional violation, the traffic violation, he executed a traffic stop. So based on what he initially observed, which he found to be suspicious based on the activity of the person who was driving, then noting that the individual who was the registered owner of the vehicle was suspended, and then noting the traffic infraction, he then effectuated a traffic stop. Following that, he noted that the individual who was driving and Ms. Reichert, who was the passenger in the vehicle, that neither of them, through the court system and through looking through leads, had a valid license. There was an inventory search of the vehicle. There was subsequently a scale with some residue underneath the front driver's seat. And even prior to that, as Officer McLeod approached the vehicle and asked if there were any weapons or anything illegal in the vehicle, Ms. Reichert then indicated that she did have 2 firearms in the vehicle, and the defendant in this matter has prior felony convictions and is under disability, and there was an indication that he in fact possess that at some point in time, so the defendant was placed under arrest. My understanding is that the issues today are specifically based on the actual stop and then subsequent search of the vehicle. And we believe that based on case law and based on the testimony today that those will be found to be unfounded, and we would ask that you deny the motion to suppress.
Thank you. Mr. Hinton?
Thank you, Your Honor. In this particular case, primarily, we are challenging the stop that was conducted. I do not believe that an individual wearing some sort of mask in January in the Cleveland area in their vehicle would amount to probable cause for a stop. This is something that folks wear when it's cold outside. I don't think that slumping would amount to probable cause either. I know that there's a lot of folks who have their seats a bit lower when they're driving for comfort and other reasons. Now, as far as the registered owner having a suspended license, I don't think that would be probable cause in this situation because the officer could not identify the driver as the registered owner. I don't think that the driver resembled the registered owner. Folks are allowed to allow other people to drive their vehicles or allowed to lend their vehicles, especially if they have a suspended license or an issue with their license. Now, as far as the traffic stop, I do concede that had this been an actual violation, that traffic stop would be probable cause for the stop.
What traffic stop? I mean the tail light?
Yeah,
all right.
the alleged allegation of ORC 4513.05. So the stop based on the traffic citation, and there's going to be evidence presented that demonstrates that statute was not violated. And after the stop takes place, I don't believe that a subsequent search was warranted. This was a situation where it turned out the driver wasn't licensed, but
neither occupant was, right?
Neither occupant was licensed.
But they didn't kick in. We had license and insurance, but they wouldn't let us prove it.
There were firearms that I know were discovered early on in the stop, but those appear to be registered to the passenger who had no disability or otherwise no reason to have those firearms. So I don't think this is a situation where further search was required. But again, I'm focused.
So I guess I want to know your primary, are you challenging the search?
I am challenging the search, but that's my secondary argument. My primary argument is the stop.
I mean, you can challenge it, why, I guess I just don't. If both occupants, if the driver was suspended, they have a right to tow the car, right?
Arguably.
Okay. All right, well, we'll talk about that later then.
But again, I'm going to put emphasis on
Well, I understand, but I mean,
stop.
why, I don't know if we need to, because I want to know what issues we need to address here. And
Sure.
if there's issues with the search, we'll deal with it, but if that's not, I guess I don't understand what the primary issue is and secondary
Well,
issue is.
that's the argument I believe I have the strongest argument on, but I am going to address both.
Okay, very well.
Thank you.
All right, statement calls first witness.
Thank you, Your Honor. Sue, call Officer McLeod to the stand.
Morning, sir. Morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Proceed. Ms. Linden, whenever you are ready.
Thank you, Your Honor. If you could please state your first and last name and spell your last name for the record.
It's Patrolman Dallas McLeod. First name is Dallas. Last name is McCloud.
Can you tell us where you're employed and what you do there?
I'm currently employed with the Painesville City Police Department, and I am a patrolman on the A platoon on our midnight shift.
How long have you been there?
I've been employed with the Painesville Police Department since August 11th of 2017, so I've been there almost 8 years.
Any prior law enforcement experience?
No, I was hired right out of the academy at Painesville.
And if you could tell us a little bit about the academy, what's your education, your background training that qualifies you to be a police officer?
We go through rigorous training over coming up on 1,000 hours of everything from law to traffic stops, building searches, drug interdiction, criminal interdiction, so on and so forth.
Are you a certified peace officer in the state of Ohio?
Yes, ma'am.
How long have you been certified?
Since June of 2017.
I want to direct you back to January 31st of this year in Painesville, Lake County, Ohio. Would you have been working on that day?
Yes, ma'am.
What capacity?
Patrolman. And I was working the north side of the city of that night.
And what shift and hours would that have been?
That would have been our midnight shift, which would have been 7 p.m. to 7 a.m.
And during the course of that, was your primary duty?
So primary duties of patrolman, we are assigned a zone in the city that we pick at our briefing. We are to patrol that zone, look for any traffic stops, traffic violations, any criminal activity that we come across to address it, and to respond to any calls that we are dispatched to.
And on that particular date, you said that you before shift, there's something that you do, something called, are you familiar with roll call?
Yes, ma'am.
What is
That's our
that?
briefing.
What is the briefing? What do you do during that briefing?
So we have a basic briefing folder where we will see any memos that are going out, any BOLOs, basically be on the lookout for any potential stolen vehicles. We'll be briefed on any incidents that occurred earlier in the day that we need to be aware of in case there's any follow-up that needs to be done, anybody of interest that we may be looking for in regards to an investigation that's currently active. And we have a warrant folder where we are able to see any active warrants that we may have or any warrants that have been issued recently.
Is that something that happens before every shift?
Every single shift.
And what's the purpose of that, to do roll call?
Basically just to inform the officers so that we know what's going on in the city at the time, and that we can be aware, like I said, of any potential problems that may arise. If there were any problems on the previous shift that we need to be aware of in case we need to monitor our problem areas more.
So if there are people that you encounter and other individuals in your department encounter, are you all made aware of that?
Yes, ma'am.
Okay. So if there are people that maybe routinely someone in your department comes in contact with, that would be something you would discuss at roll call?
Yes, ma'am.
Okay. And on the date of January 31st, 2025, were you in uniform and were you in a marked patrol car?
Yes, ma'am.
Okay, can you explain for me what, if anything, occurred with the defendant in this matter, Lorenzo Robinson? How did you come in contact with him?
So I was patrolling the area of Cortland and Nebraska Street. It's one of our known high crime areas. It's an area that, especially when I'm working the north side of the city, I patrol quite often. I was traveling southbound on Cortland Street when a black 2017 Chevrolet Trax, Ohio registration KAC 8000, passed me traveling in a northbound direction on Cortland coming from East Jackson Street.
What time was this when this happened?
Close to about 11 o'clock at night.
So would you describe a little bit about the conditions outside?
It was cold. It was very lightly snowing outside.
Light, dark?
It was dark out.
And I think you said, what time was it? You just said that.
It was just before 11 o'clock at night.
So 11 o'clock p.m.?
Yes, ma'am.
So as you're patrolling that area, how is it that you come in contact with the defendant in this vehicle that you described?
So as the vehicle's passing, commonly as I'm passing vehicles, I tend to look in the vehicles to see if I recognize anybody who's driving the vehicle. As the vehicle passed me, I observed the operator was wearing a black face mask that covered his entire face. As he passed, or I should say, as they passed me, I observed the operator to sink down in their seat. Prior training and experience has taught me that that is indicative of individuals that are attempting to avoid police contact by attempting to break our line of sight with them.
Now you changed from his to they. Why did you do that?
Because at first I know I said they based on the outcome of the investigation. However, as the vehicle passed me, I did not know who was driving. All I saw is the individual was wearing a black face mask. I could not tell if they were male, female, black, white, Hispanic. I was not able to tell.
Okay. And when you see the vehicle, if you're familiar with people in the way that everybody sits a little differently in their driver's seat.
Yes, ma'am.
Okay. And in this case, did it appear that this seat had been pulled back? Was it in a normal position?
I could not see the seat. It was hard to see the seat. All I saw was the operator. As they passed me, they appeared to sink down in the seat.
Okay. So you made a movement when you did that. So if you could explain as you're doing what specifically you saw.
So as the operator was passing me, I saw them driving, and as they see me, I'm looking at them, and they kind of sink down in their seat like this.
So you leaned back and then actually kind of pulled your body down.
Yes, ma'am.
And you actually observed this occurring as you passed that individual.
Yes, ma'am.
Okay, so what did you do?
So at that point, that drew my attention to the vehicle immediately. As the vehicle passed me, I looked at the license plate, which was KAC 8000. By that, I ran a random registration check of the vehicle through LEADS, which is the Law Enforcement Automated Data System. It's a program we have in our MBTs in our cars that allows us to run license plate and to see the registered owner of the vehicle and any information pertaining to the vehicle. Excuse me. At that, I was able to see that the owner of the vehicle, Stacy Reichert, was showing to have a suspended license.
And when you look at that and you realize that the person who's a registered owner of the vehicle has a suspended license, what do you do?
So at that point, I turned around. I had observed the vehicle start traveling westbound on Nebraska Street prior to turning back around. I relocated the vehicle traveling westbound toward Richmond Street on Nebraska Street.
How did you know it was the same vehicle?
It's the only vehicle that was on the roadway or on the street.
Okay. I'm going to stop you just for a second. I'm going to back up just for a second. When you see this individual, you're looking over the car, do you know whether the window is up or down in the car?
It was up.
So the window was up. And could you tell if any of the windows in the vehicle were tinted?
I was unable to tell.
Okay.
But you could see through the driver's side window.
Yes, sir.
And so in this particular situation, with the tinting on the window, it was clear enough that you were able to actually see into the vehicle and see this?
Yes, ma'am. In front driver compartment, yes.
Okay.
So at that time when you saw, you didn't know if there was a passenger in the front seat.
I was unable to tell. I could not see. All I saw was the driver.
Very well.
So that was my next question. And were you able to see the number of people that were in the vehicle?
No, all I saw was the driver.
Okay. So then when you ran the plate, why did you then continue to look for this vehicle, or you said relocate the vehicle?
Because again, based on the actions of the driver, it drew my suspicion to the vehicle that, again, the operator was attempting to avoid me for some reason. Especially that the owner was showing to have a suspended license. I wanted to see if I was going to be able to stop the vehicle for some kind of infraction. Again, I relocated the vehicle traveling westbound in Nebraska towards Richmond Street.
Let me stop you for 1 second. Actually, I only testified this. I just want to summarize this. You ran the plate. You learned the driver was it Lisa Reichert? Lisa Reichert?
Stacy Reichert, sir.
I'm sorry, Stacy Reichert. And you learned that Stacy Reichert had a suspended license.
Yes, sir.
All right. Good.
And were you able, well, are you familiar with Stacy Reichert?
I am.
Okay. And in being familiar with her, were you able to tell when you initially saw that individual that was the driver in the vehicle, whether that was Stacy Reichert or not?
No.
And
No,
why was-
what? You couldn't tell or no?
No, I was unable to tell if that was Stacy.
And why was that?
Just based on the face mask and the dark, I was unable to tell. Like I explained, I was unable to tell if it was a male, female, black, white, Hispanic. I could not tell.
All right. So then you relocate the vehicle. What happened?
So I observed the vehicle approaching the intersection in Nebraska and Richmond Street, where upon application of the brakes by the operator, I observed the right rear tail light to be broken, and the brake light was emitting a bright, visible white light.
When you talk about the tail light, describe what you're talking about.
I'm sorry?
The tail light. What do you mean by when you observe the tail light? What portion of the car?
So at the rear of the vehicle, the right rear of the vehicle, there is the red tail light, which is required to emit a red light when actuated, either the tail lights or the brake lights. By this, when the light was, or when the brakes were applied and the light was illuminated, it emitted a white light instead of a red light.
What's the problem with that?
It's required by law that it emits a red light, not a white light, for the brakes.
And so what do you do?
So at that point, I stopped the vehicle. I conducted a traffic stop based on the equipment violation, where I approached the vehicle and I identified the operator as Lorenzo Robinson and the front seat passenger as Stacy Reichert.
And when you approached the vehicle and you went to speak to the driver, what did you do specifically?
So I have a standard practice, especially with the new constitutional carry law, where I ask everybody on every single stop I do if they have anything illegal inside the car, any guns, knives, drugs, or anything I need to be concerned about in the vehicle. It's just a common practice I do. At that same instance, as I'm talking and I'm asking the occupants if there are any weapons inside the vehicle, Miss Reichert begins to explain to me she has 2 pistols in the car. At that same time, I turn on my flashlight to get a better look inside the car and illuminate the interior of the car, where I observe 2 black pistols that are against her left leg.
Okay. And prior to that, when you actually stopped the vehicle and came up to the vehicle, what if anything did you observe about the driver? What was he wearing?
So again, he was wearing a full black face mask and he had a black hooded sweatshirt that the hood was pulled up over his head.
When you went up to the vehicle, did you ask any questions initially, other than about the firearms? Did you approach the vehicle? Did you talk to them about the reason for the stop or any other information?
I advised them for the reason well, once I ID people, I advised for the reason to stop.
Okay, so you did identify the people. You asked them who they were?
Yes, ma'am.
Okay. And you said you were familiar with Stacy Reichert?
Yes, ma'am.
And were you familiar with Lorenzo Robinson?
Yes, sir.
Okay.
Yes, ma'am. I'm
How
sorry.
were you familiar with Lorenzo Robinson?
Several prior instances and calls in regards to him.
Okay, so you knew who he was?
Yes.
And you knew who Stacy was?
Yes, ma'am.
Okay. And when you came up to the vehicle and you were able to identify the driver and the passenger, were you able to then tell who was driving the vehicle?
Yes.
Okay. And so at that point in time, you knew it was a male and it was Lorenzo Robinson?
Yes.
All right. So after you asked a question then about anything in the car, what do you do then?
Are we going back to after I had observed the pistols? Okay. So I observed the pistols. I could see that the slides were locked to the rear on the pistols and the magazines were removed from the guns. At that point, Officer Witt was arriving on scene with me. We requested additional units there just based on the instance and the firearms being in the vehicle, where we asked Ms. Reichert to step out of the vehicle just mainly for officer safety to distance themselves from the weapons. She was patted down for weapons. We asked her to stand off to the side. Lorenzo was then asked to exit the vehicle where he was patted down for weapons and instructed to stand in front of my cruiser.
And when you were able to shine your flashlight in the car, tell me what you saw on the seat there.
So where Ms. Reichert was sitting, the two pistols were stacked directly on top of each other. As I had previously explained, the slides were locked to the rear on both of the firearms, and the magazines were missing from the mag wells on both. The barrels of the pistols were facing toward the dashboard, and both the magazine wells were facing toward Lorenzo.
Was there anything else you noted on the seat?
Right in front of the pistols, there was a bag of a green leafy substance that, from prior training experience, I identified as suspected marijuana.
Okay. I'm going to ask you to, just so that we have a better understanding, a little demonstration here. These are 3D printed plastic.
Okay, I mean, you can do what you want to do, but what's the purpose of this?
I'll explain it.
But in terms of the issues for the suppression?
Just in terms of what the, part of what Officer McLeod observed and why subsequently there was more information as to why then there was an additional search of the car.
So it's not just based on inventory?
It is based on inventory, but there is some additional suspicion then that the officer had based on what he observed.
Okay.
You can step down, Officer McLeod. I'm gonna, just here, pretending that this would be the, is it similar to the way that the seats are in that vehicle?
Yes,
where
ma'am.
the wheelchairs are?
Yes, ma'am.
Okay, and then in the driver's seat, this would be Lorenzo Robinson?
Yes.
Okay, and if I'm the passenger and I am Stacy Reichert, can you show me where these two guns would have been, what location, the way?
These two pistols would be situated right there. Bag of marijuana was right here.
Okay, and so basically this portion of it, they can handle it, that's actually facing towards the driver?
Correct. The magazine wells were facing toward Mr. Robinson.
Okay, and then you could tell, that's why you could tell that there were no magazines in the car?
In the weapons, yes.
I'm sorry, in the weapons. And is that the reason that then you asked Ms. Reichert to get out of the vehicle?
Yes.
And the defendant as well?
Yes.
And then, when you observed the firearms in that particular position, was there any concern that you had?
Mainly just an officer safety issue, especially with the weapons. We didn't know where the magazines were. We didn't know if they had access to them, so we wanted to distance them from those weapons.
Okay. So you knew that the now passenger was the one that had the suspended license. What, if anything, did you learn about the driver of the vehicle and whether or not he had a valid license?
So Mr. Robinson was ran through Central Dispatch and through Leeds, where he was found to be under multiple active license suspensions.
And that was after you observed the firearms?
Yes, ma'am.
So that, you then, at that point in time, what are you going to be required to do?
So per our policy, we are required to impound the vehicle based
Why
on
is
the
that?
based on the operator having a suspended license and the owner of the vehicle having a suspended license.
And the roadway where the stop occurs, specifically, where was that?
So it was just in front of Richmond Food Mart on Richmond Street.
And was it actually on the roadway?
Yes, ma'am.
And are you permitted to leave vehicles on the roadway?
No.
And just for the record, I'm showing opposing counsel what I provided to him. I'm showing him State's Exhibit 6. May I approach?
Yes, you may.
Officer McLeod, I'm showing you what's been marked for identification of State's Exhibit 6, and just ask if you could look through that. Let me know when you're finished. What is it that you have in your hand there?
So that is a copy of the Painesville Police Department Policy 502, which pertains to the vehicle towing and release policy that we have.
Okay, and that particular policy, that's what you're referencing here, is the tow policy?
Yes, ma'am.
Okay, and is that what you followed here in this case?
Yes, ma'am.
And there are how many pages of this?
There was 3.
And so leaving a vehicle in the middle of the roadway is something you're not permitted to do?
Correct.
Okay, and what did you do then Once you realized that both of the individuals that were there were suspended, what did you do with the vehicle?
So based on that, we are required by policy to conduct an inventory of the vehicle for any items of value, which means checking for any place an item of value may be stored, any containers, whether they're locked or not, or any areas, bags, containers, or anything like that as to where an item of value will be stored. That way we can document them in the tow file.
And is that the reason that you searched the vehicle in this case?
Correct.
Okay. And was there anything additional that was located?
So upon doing an inventory of the vehicle, Officer Belowski and Officer Witt conducted the inventory of the vehicle for me. Officer Belowski located a digital scale in a box underneath the driver's seat that appeared to have a white powdery residue on it. Also, Officer Witt located on the passenger floorboard a ejected 10mm round on the passenger floorboard of the vehicle.
All right. And all those items that were collected as evidence?
Yes, ma'am.
All right. Now, this stop that you conducted, was that memorialized in any way?
So all of our traffic stops, or I'm sorry, all of our police cruisers have a mounted watch guard camera in it that has 3 different views. It has a front narrow view, a front wide angle view, and a back seat view. Upon the activation of our overhead lights, the recording is activated. The audio on the recordings don't start for about 30 seconds as the video starts 30 seconds prior. Audio activates when we activate the overhead lights.
Okay. And do you have body-worn cameras?
We do not have body-worn cameras, no.
Is there anything else on your uniform that helps capture what happened?
So attached to the dash cam, we have a body mic, a watch guard mic that we wear on our vests that captures all audio from the encounter.
Your Honor, for the record, I'm showing opposing counsel what's been marked as State's Exhibit 1. Option 5, I'm going to hand you it to mark for identification of State's Exhibit 1. Ask you to take a look at that and tell me if you recognize what that is.
Yes, this is a copy of my dash cam from Painesville Police Department, Cruiser 729, from the time of this incident.
And how do you know it pertains to this incident?
It has the CR number on it and the subject's name on it, State versus Lorenzo L. Robinson.
And have you had an opportunity to view that?
I did.
And did that fairly and accurately depict what we know to be then now your cruiser video?
Yes, ma'am.
Okay, and how do you know that?
I'm sorry?
How do you know that? Is there something on the disc that lets you know that you've seen this?
Oh, yes, I initialed it and put my badge number on it.
Your Honor, at this point in time, I ask to publish this then.
Any objection to the admission of State's Exhibit 1?
No grounds for objection, Your Honor.
One will be admitted, and you may play that at this point.
Your Honor, for purposes of the record, we will be playing stream 0, which is not the wide angle and not the backseat, but actually the stop itself.
Okay. Yep.
So when the video first starts, I was on East Jackson Street by our Buildings and Ground Department, currently turning around to go back to Cortlandt Street to begin following the vehicle down Nebraska Street. Right now, where you stopped the video, we are currently traveling westbound on Nebraska Street toward Richmond Street.
Why is it that we don't see on this video the car passing you and the individual that's in the
As I had previously explained, the video only goes back so far. It goes back about 30 seconds prior to me activating the lights. So 30 seconds before I activate the lights is where the recording actually begins.
The dash cam's not on all the time.
Correct.
Your Honor, for the record, I'm showing opposing counsel is marked as State's Exhibit 3. It's this one. Officer McCall, I'm going to show you what's been marked for identification State's Exhibit 3 and ask you if you recognize what that is.
Yes, ma'am.
What is that?
So that is the general area on Cortlandt Street, where when I was traveling southbound on Cortlandt Street, the vehicle passed me traveling northbound on Cortlandt Street before it turned onto Nebraska.
Okay, so what do we see actually in that particular photo? Is that a screenshot from this video?
Yes, that is a direct screenshot from my dash cam prior to me turning onto Nebraska Street.
So at the beginning of this video, we can see that you're traveling and there's a vehicle in the video. Is that the initial area where you saw the defendant?
Where the vehicle was parked on the side of the road?
Yeah.
Yes.
We go back. Okay, so when we turn, where are we turning now?
So right now we just turned from East Jackson going onto Cortlandt Street traveling northbound.
Okay, and you see there's the vehicle that's there on the left-hand side of the screen.
Yes, ma'am.
Where in proximity to that did you see this vehicle initially?
So let me use your pointer. I was traveling southbound on Cortlandt Street and I was right about here. The vehicle passed me traveling northbound on Cortlandt right about here.
So this is where you then initially observed the vehicle?
Correct.
Okay, what road have you turned onto now?
So now this is going westbound on Nebraska Street.
And if we're looking at the bottom left, so that is at around 33 seconds?
Yes.
So this is, just get my bearings straight here, all east of Richmond Road, right?
Yes.
Okay.
Yes, we are.
Now you're heading towards Richmond Road.
Now we are heading toward Richmond, correct.
Okay.
And what have we observed thus far then? What are you doing?
So another standard practice I do when I see vehicles, I usually will tail them from a distance and I'll watch them from a distance. At the point where the vehicle got to that intersection and I observe the violation, you will see my cruiser, I begin to speed up because I know I'm trying to catch up to the vehicle at that point to initiate the traffic stop.
Okay, I'm going to stop the video here around 109. Can you tell me, you described what you observed on the vehicle. Can you show us on the screen with a pointer what you're talking about?
So what I'm talking about where it was emitting a white light was from this tail light. This tail light was broken and it was emitting a white light when the brakes were applied.
Now, you can see a little bit of red in there as well. Were you able to see any of that red from where you were?
I'm sorry?
The red, there's a little bit of red that you can see in there. Does that cover the entire portion of the light, or
No,
was that intact?
no.
Adam Charles 8000, King Adam Charles 8000, it's a black Chevy, unknown occupants.
So where's the white lights coming out? Coming out from the bottom. Is that what you're alleging?
I'm sorry,
Not
sir.
now, obviously, but, never mind, go ahead, Ms. Linden.
When we're looking at the video here at 120, can you explain a little bit better view of this? What exactly are we seeing here, and how can we see what you're talking about?
So what you can see what I'm talking about is this, as you can see, this taillight is completely intact. This taillight was not broken at all. This taillight, as you see, the bottom portion here was broken. It was covered, there was covered partially by a red tape. The top of this light was completely white. It was still completely broken out, which this whole portion here was emitting a white light when the brakes were applied.
Right now, the brakes aren't applied in that car, is it?
Correct.
So it's in park?
Correct.
I'm gonna show you what's the, I'm showing the opposing counsel was marked for identification states exhibit 4. That's this one. I'm gonna show you it's been marked as states exhibit 4 and ask you if you recognize what that is.
Yes, this is a still shot from the dash cam of the vehicle.
And what do we see in that exhibit?
So this is, again, this is a still shot where you can see the tail light being broken at the bottom, where it's clearly different from the other tail light.
You see that? Do you need a witness to have this though?
How you doing, sir? Officer McCloud, Mason City Police Department. You got your driver's license for insurance on you, pal? Okay, you got your driver's license on you? What's your name? Lorenzo? Okay. Stacy, right? Yeah. How you doing, hon? Lorenzo, what's your social, buddy? Okay. So the reason why I'm stopping you guys, all right, when you hit the brakes, your back tail light's busting, it's emitting a white light. You can't have any white light on the rear of your vehicle except your reverse lights and your license plate light. Okay? Is there anything illegal inside the vehicle? Any guns, knives, drugs, anything crazy I need to know about? What's that?
I have 2 guns.
You have 2 guns with you? Where are they at? Just... Okay. Okay, do me a favor. Don't touch them. Leave them right where they are, okay? And if you could, for right now, could you just step out toward Officer Whip? Are either one of the firearms loaded?
Nope.
Okay.
They're right there.
Okay.
Let's stop for just a second. When you came up to the vehicle, and you looked into the vehicle, it sounded like you recognized somebody that was in there.
Yes, ma'am.
And was that the first time that you knew that that individual was in the car?
Yes.
So when you came up to the vehicle, you didn't know that Stacy Reichert was in the car until you actually observed her in the passenger seat?
Correct.
And when you came up and you spoke to the driver of the vehicle, you asked him for his license?
Yes.
What was his response?
He advised me he did not have one on him.
So you didn't have one on him?
Correct.
847 social. 290-94-1527. 290-94-1527. So you got a driver's license, bud? You're working on it? Okay. Do me a favor, can you shut the car off for me, pal? Appreciate it. Do you have any weapons on you? No weapons on you?
So when you're stopping in here at 312, we just, in the conversation that you're having with the driver and asking about his license, his response is that he's working on it?
Yes.
So he, at that point in time, he's just told you he doesn't have a license, but have you verified that?
So no, I ran his social through our central dispatch. They had not given me a return on it, but no, he basically told me he did not have a license.
So at this point in time, knowing that Stacy Reichert does not have a license and that the driver does not have a license, what is going to happen?
So at that point, the vehicle is going to be impounded.
Okay. That's not. Put your hands right up here for me. Just get patching off weapons real quick, okay, pal?
Social to Lorenzo Robinson, 33-year-old male, suspended with another confiscation driver's license on behalf of the registrar. -1 last moving, no one.
Do me a favor, take a seat on my push bumper.
I'm stopping it at 337, so for purposes of the record, who are you walking back with?
So I am walking back with Mr. Robinson at that time.
Okay, and what can we observe that he is wearing?
So he's wearing what I observed him to have been wearing at the time he passed my vehicle, with the black face mask on with the black hood pulled up over his head.
Okay, when we look at the black face mask that we see
No.
And how is it different?
So when he passed me, it was further up on his face. Appeared to be just under his nose or on his nose.
And so with that and then a hoodie, were you able to see who the individual was?
No.
Copy.
That's my lead.
Okay. Officer Blasky, can you stand with Mr. Robinson, please?
They might come back soon, Sunday, I just got the notification today.
Okay, I'm gonna stop here just for a minute. This is at 4:01, and then I'm showing opposing counsel is marked for identification as State's Exhibit 5. I'll show you what is been marked as State's Exhibit 5. Can you take a look at that and tell me if you recognize what that is?
Yes, this is another still shot of the vehicle from my dash cam.
Okay, and is that what we're watching right now?
Yes, ma'am.
What of significance can you see in that photo and on the screen here?
So again, right here, where you see the busted tail light, where the top of it is white, clearly completely different from the top of this tail light where it is red, and also this bottom portion which had a tape over it which was still emitting a white light through it. So the top portion of this and this bottom portion was emitting a white light when the brakes were applied.
So in State's Exhibit 5, when you're looking at it, is it easier to see in a still shot what you're talking about?
Yes, ma'am.
Where's that?
Okay.
And so at this point in time, even though it has some tape over it, it's emitting a white light, and that's in violation of the law.
Correct.
I did just reinstated
Stacy, can you come here, hon?
and my phone.
I want you to be honest with me. It's very, very odd what's going on in the car right now.
One, why is there two guns in the car? Why does one not have a magazine taken?
Why is the magazine taken out of the one?
They actually got both of them.
What's that?
The clips got the both of them.
What?
Because that's the way I was
Okay.
because Michael Beaver is back
No
out.
longer have I contacted
And
Anna.
I have a restraining order, and he's been seen around me.
I'm going to stop at 442 here. Have you gotten back confirmation that the driver does not have a license yet?
Yes.
Okay, and so at this point in time, what are you doing?
So prior, when I was standing, if you would had rewound back to when I was patting him down for weapons at the side of the vehicle, you would hear my dispatcher come over to my radio and advise me that Lorenzo Robinson was suspended with a note to confiscate his license if he had it by the registrar. So at this point, Officer Belowski and Officer Witt were standing with Lorenzo at my cruiser. I pulled Stacy off to the side to have a separate conversation with her.
Now, was there something that she indicated to you about her license?
I'm sorry?
Was there something that she talked to you about, something she had on her phone, or something about her license?
She advised me something about something through BMV that gave her permission to drive or something in that nature. However, there was no indication of it through the state computer and through leads.
And if an individual has some kind of driving privileges, what is required for you to have?
So by that, you are required to carry a copy of the court documentations indicating what driving privilege you have and for what specific reason. You are required to carry them with you while you are driving.
But in checking through Bureau of Motor Vehicles and looking through leads, both of these individuals showed to have suspended licenses.
Correct.
So at this point in time, what are you required to do with that vehicle?
By that, per our policy, we're required to tow the vehicle.
Okay, and have you called for the tow yet?
I don't believe so at this point.
Okay, but then at some point in time, you then do call for a tow.
Yes.
Is there more that you would like to show, Mr. Hinton?
Not at this time.
And I'm going to be stopping you then at 442, believe that addresses the discussion that we had about the stop and the reason for the subsequent search.
Thank you.
You want me to leave this here?
Yes, please. Thank you.
All right, so Officer McLeod, the individual that was driving the vehicle without a license, who was that individual?
It was identified as Lorenzo Robinson.
And do you see that person in the courtroom here today?
Yes, ma'am.
And could you please point that person out, describe what he's wearing?
He is the African-American gentleman wearing the blue jumpsuit sitting directly next to the defense attorney.
And I have anything further at this time, thank you.
Thank you. Cross-examination, Mr. Hinton.
Thank you, Your Honor.
I got the other two. I've just got 4 and 5 right here. There should be 1 and 6 and 3. I'm not sure if 2 is identified or not.
2 is not. We won't be using those.
No, I don't have the policy.
So the dash cam is 1. Huh?
Oh, I have it over here, Your Honor, sorry.
If we can keep the policy handy.
Absolutely.
I'll just give it to him then.
Okay.
Go ahead, Mr. Hinton.
Hi, good morning, officer.
Good morning, sir.
The date of the stop in question was January 31st, 2025,
Correct, sir.
and it was cold outside.
Yes.
And in the footage that we watched, you can see snow on the ground.
Yes.
And the passenger in the vehicle, Stacy Reichard, she was wearing a hat, correct?
Correct.
Now, the mask that Mr. Robinson was wearing wasn't a ski mask that had holes for the eyes, correct?
Correct.
And you had indicated that the mask that we saw in the video was the same mask that you observed him wearing when you initially observed the vehicle, correct?
Yes, sir.
And you indicated that that mask was pulled up to his nose?
Yes.
Okay. But you couldn't tell his race or gender?
No, based on how dark it was and the face mask and how dark it was in the vehicle, all I saw was the face mask over someone's face and the hood pulled up over the head. That's all I could see.
And just covering his mouth, right?
It was about right at his nose.
And you couldn't see if there was a passenger or not?
No.
Okay. But you didn't pull over the vehicle right then and there, correct?
Correct.
And as far as the slouch, you believe that the driver slouched down after seeing an officer?
It's very common with individuals attempting to avoid police contact and to break our eye contact with them, yes. So it drew my suspicion and drew my attention to the vehicle.
Now, you weren't able to see the race, gender, or the passenger, but you were able to see a slouch?
Yes, sir.
But you didn't pull the vehicle over at that time, right?
No.
And it wasn't until you observed the right brake light emitting white light until you effectuated a stop of the vehicle, correct?
Correct.
And when you approached the vehicle after stopping it, you listed that as the reason for the stop, correct?
Correct.
And you indicated that the white light emitting from the brake light or tail light was a violation of law.
Yes, sir.
It is that ORC 2513.05 tail lights and illumination of rear license plate.
Yes, sir.
And that's the statute you cited in your report, correct?
Yes, sir.
And that's the statute that you issued a citation for in the Painesville Municipal Court?
Yes, sir.
Other than that citation, were there any other, well, let me rephrase it, other than that citation and the driving without a license, were there any other traffic violations that you cited Mr. Robinson for?
No, I cited him for the equipment violation and driving under suspension and no operator's license.
And again, just to be clear, when you say equipment violation, you're referring to 4513.05?
Correct, sir.
Now, you had indicated that you couldn't tell who the driver of this vehicle was. You testified.
Correct.
To that, right? Now, in your report, you did indicate that you were familiar with the male who is known to operate Stacy's vehicles, Mr. Robinson, and you suspected he was the operator, but you were unable to positively identify him upon passing?
Correct.
Why did you suspect that he was the operator?
He's been stopped multiple times in Stacy's cars. He's known to drive Stacy's vehicles. And I know other officers who have had similar encounters with him when, upon passing, he would do similar motions.
Okay. So you were more of the opinion that it was Mr. Robinson driving than Ms. Reichert driving the vehicle?
I suspected, but again, I couldn't confirm.
Okay. And at that point in time, you did not know the status of Mr. Robinson's license because you had ran that after the stop, right?
Correct.
You had indicated that after confirming that the driver didn't have a license and the passenger didn't have a license, that pursuant to policy, you'd have to impound the vehicle.
Yes, sir.
May I approach
You
you?
may.
I'm going to hand you what's been marked as Exhibit 6, and I'll flip to the second page. So the second page of Exhibit 6, 502.4, indicates towing at arrest scenes. You see that?
Yes, sir.
And then it indicates officers are given discretion when it comes to towing vehicles.
Yes, sir.
And then there are times when a vehicle must be towed, and then there's a few reasons listed, right?
Correct.
Okay. So what gave rise to you not being able to use your discretion and you having to tow the vehicle?
Well, the operator being suspended, the passenger being suspended, who was the owner of the vehicle, and also her indication later that she knew Mr. Robinson did not have a driver's license, which is a violation of 4511-203, which is wrongful entrustment.
Okay, so there's 4 things listed. There's in conjunction with the OBI statute and the 4511.203, and then when a vehicle is a traffic hazard, innocent owner, stolen vehicle, snow ban, or a vehicle taken as evidence. So out of those 5, you're indicating and testifying that the reason you felt you had to impound and tow the vehicle was in conjunction with 4511.203?
Correct. That and the fact that it was a traffic hazard.
Now, as far as 4511.203, Ms. Reichert wasn't charged under that statute, right?
She was charged under a city ordinance which pertains to that statute.
And when was she cited with that?
That night, at the time of the stop.
Okay, but it wasn't under the revised code?
Correct, but it was under our city ordinance, which is in conjunction with this revised code.
And then as far as the vehicle being a traffic hazard, why was it a traffic hazard?
Well, no one was able to move it. We didn't have a valid driver to move it. Also, with the revised code, it was unable to be driven, so it couldn't stay parked on the roadway, which if we left it on the roadway on Richmond Street, it's a 4-lane traffic way, it would have been a traffic hazard.
How long did this traffic stop take total?
I honestly don't recall.
Was it more than 20 minutes?
Correct.
Okay. And during that period of time, was there any efforts made to have a licensed driver move that into the parking lot that was adjacent to where the car was stopped?
No.
And you indicated that Ms. Reichert did attempt to show you something on her phone, giving her the right to drive?
She indicated she had been sent something by the BMV, but was unable to provide proof of it.
She indicated it was some sort of driving privileges?
Something in that nature. But again, I was unable to provide any kind of proof of it. and there was nothing showing through leads as showing any sort of driving privileges for the suspension she was under.
Okay, I have no further questions, Your Honor.
Redirect examination.
Thank you, Your Honor. So, Officer McLeod, when we're looking at that 502.4, there being a traffic hazard, when we watched the video, you could see where the vehicle was stopped. Would you have been able to just leave the vehicle there?
No.
And per your department policy, then would you have been able to just take that car and go ahead and drive it over and leave it maybe in some other lot?
No.
Why not?
It's private property. I can't give them permission to park their vehicle on private property.
And when you're looking at the individual that's going by in the car, since you're not able to tell who it is, even if you suspect that it might be Lorenzo Robinson, were you able to determine that that's who that was?
No.
So at that point in time, did you know if it was Stacy Reichert or if it was somebody else?
No.
And if you see a vehicle that's registered to somebody who does not have a license, what are you required to do?
I'm sorry?
What are you required to do if you see a vehicle that's driving and the individual that's registered to does not have a valid license?
Well, there's case law that indicates that that is probable cause for a stop, an investigative stop, to ensure that the operator, if the operator is the, I'm sorry, you're able to stop the vehicle based on the owner showing to have a suspended license, is what I'm trying to say.
At that point in time, you only see one person in the car.
Correct.
Can I just have a moment, Your Honor?
Mm-hmm.
I have nothing further then. Thank you, Your Honor.
Recross.
Now, sir, upon the vehicle being towed or impounded, that's what triggered an inventory search?
Correct.
Nothing further, Your Honor.
All right, sure, you may step down.
Thank you.
Let's take a 5-minute break, and then we'll resume.
All rise.
All right, we are back on the record. Mr. Robinson, you're able to use the restroom?
Yes, thank you.
Good. Ms. Linden, you may call your next witness.
Your Honor, the state has no further witnesses. With the omission of our exhibits, we would rest.
Mr. Hinton, any objection to any of the exhibits? I have a 1, 3, 4, 5, and 6.
No grounds to object to those exhibits, Your
All
Honor.
right, so those 5 exhibits will be admitted. Does the defense have any witnesses?
No, Your Honor.
All right, then I will hear closing comments from the state.
Thank you, Your Honor. Your Honor, in this matter, based on the violation that was observed by Officer McLeod, the state would submit that there was, in fact, probable cause. Even though prior to that there was some reasonable suspicion that there was some kind of criminal activity afoot by the actions of the driver of the vehicle, he then also had the fact that the individual who was a registered owner of the vehicle, and there was appeared to Officer McLeod that there was only one occupant at that point in time, that being the driver, was under suspension. I would also submit to the court that in addition to 4513.05 governing tail lights and rear illumination, there is an additional statute, 4513.071, that governs stop lights on a vehicle as well, and does require those lights to actually have the red over top of them, and it says that they shall actually emit a red light visible from a distance of 500 feet to the rear. Even though there may have been some tape on the back of this particular light, in watching and observing it from Officer McLeod's perspective, and in the video you can see that it emits a white light, and that was a valid reason for a traffic stop. Following the traffic stop, then there, as I had indicated in opening, neither of the individuals in the vehicle had a valid license per the tow policy, based on the wrongful entrustment, not to mention the fact that the vehicle could not be left on the roadway. The vehicle had to be towed, had to be inventoried, and as a result of that, we were asking that the motion to suppress be denied.
Mr. Hinton for the defense.
Thank you, Your Honor. In this particular case, I had questioned the officer about the reason for the stop. As far as the mask goes, the testimony was that the mask was pulled up to Mr. Robinson's nose. It was established that it was cold out. It was the end of January. There was snow on the ground. Ms. Reichert was wearing a hat. In the video, you see the face mask, and it's not a ski mask that would just have holes for the eyes or anything of that nature, and if it was pulled over his mouth, there's still certainly a large part of his face that's visible, so I don't think that in itself, or combined with other factors, would provide a probable cause or reasonable suspicion to stop the vehicle. As far as what was perceived to be a slump or an effort to lower himself, again, I don't think that creates the proper level of probable cause or reasonable suspicion. As far as the random check of the license that led the officer to realize that the registered owner of the vehicle was suspended, the officer testified he couldn't tell who was driving the vehicle, but I think it's important that he suspected it was Mr. Lorenzo as opposed to Ms. Reichart. And at that point in time, the officer didn't know that Mr. Robinson didn't have a license, but the stop didn't take place until there was this observation of the right tail light, brake light being out. That was the stated reason for the stop. That's what the traffic citation was for. And if you look at that statute, 4513.05, it's interesting in that it indicates that every motor vehicle, trackless trolley, trailer, semi-tractor, pull trailer, or vehicle which is being drawn at the end of a train of vehicles shall be equipped with at least one tail light mounted on the rear, which lighted shall emit a red light from a distance of 500 feet to the rear. The officer testified that the light on the left was fully intact. I made the testimony pretty clear that this was the statute that was being referred to by the officer for the stop. And again, that statute only requires one tail light to emit red light, and there was one tail light emitting red light in this situation. The second paragraph of that statute, it talks about having a tail light that can emit white light to help light up the license plate. So in this situation, I don't believe this statute was violated because there was one working tail light. And if you look at, for comparison purposes, the headlight statute 4513.04, that mentions two headlights other than a motorcycle. So it's very clear that you only have to have one tail light that emits a red light, and that's what was here. So as a result of that, I don't think that there was probable cause for the stop based on the alleged violation of this statute. I don't think the other reasons would amount to probable cause, so I don't think that the traffic stop was proper. As far as the search, I would indicate that I don't think an impound or a tow was necessary. And looking at Exhibit 6, and this is the Painesville Police Department's policy. It's not a policy from the state, but it talks about the Ohio Revised Code and the wrongful entrustment. Ms. Reichard was charged under the city statute, city ordinance, not the Ohio Revised Code. This doesn't say in conjunction with 4511.203 or a local code. I don't think the vehicle would have been a traffic hazard. You could tell in one of the state's own exhibits that there's another vehicle parked on the road. I understand this was a main road, but
Let me ask you a question. Even if they didn't have to do that, they were able to do it, they were permitted to do it. This policy says it's discretionary. They're allowed to do it, right? They don't have to they don't have to tow a car just because they're required to. They're allowed to tow the car discretionary also.
I understand that. I believe that the testimony was more so that this would be a...
Well, I mean, that's what he testified to, sure. I'm not arguing with you there, but there was nothing that said it was improper to tow the car.
Sure. Understood, Your Honor, but we don't get to that point if the traffic stop isn't made.
I understand on that.
And I don't think there was proper grounds for a traffic stop. Thank you.
Ms. Linden, rebuttal?
Your Honor, I just point out again that if you're looking at some of the case law that's involved, it does say there can be a lawful stop even to ensure that a car is operated by a properly licensed driver. And here, the officer did not know that, and 4513.071 does govern the stoplights, and it does say that every motor vehicle, trailer.
The case you're citing is if they have reason to believe the owner of the vehicle is suspended, not just any vehicle.
Correct, Your Honor.
So you're saying that if they have reason to believe the owner of the vehicle is suspended, and they're unsure whether the owner of the vehicle is operating the car, they are permitted to do a stop to check.
Yes, Your Honor, that's what the case says.
What case is that?
That is State versus Dunlap, and it's 2024 Ohio 4821, and it also references People versus Cummings, which is 2016. It's an Illinois case, but it does talk about the United States Supreme Court's decision, talks about it, and Rodriguez says that it's clear that a driver's license request of a lawfully stopped driver is permissible, and then they're also looking at when they're doing a valid traffic stop if it means checking the identification, even if the reasonable suspicion that formed the basis for the original stop had dissipated. So it does allow for that. And 4513.071 specifically states that every motor vehicle when operated upon a highway shall be equipped with 2 or more stoplights, except about other cars that are historical in nature, and that when they're actuated shall emit a red light visible from a distance of 500 feet to the rear. And it should be a steady warning light to the rear of the vehicle for individuals that are behind that. So even if looking at 4513.05, if you only need one, when you're looking at the stoplights, which is what we're talking about as well here, there's another statute that's violated in addition to the fact of the not properly licensed driver. So again, we would ask that the motion to suppress be denied.
All right, I'm going to take a brief recess and then I'll return. We are back in the record that this time this court has considered the evidence and testimony presented during this hearing, the arguments of counsel. I've considered, obviously, the motion that was filed, the response by the state of Ohio, and in considering the foregoing, I make the following findings. In this case, the evidence established that the police officer, while on patrol, observed this vehicle with the driver slumped down and a mask covering most of the driver's face. This does not provide a basis for stopping the vehicle. I'm not making that finding one bit, but the significance of it is what drew his attention to the vehicle, drew his attention to the car. I find the evidence established that when the officer observed this car, and specifically the driver being slumped down with the mask, he could not determine anything about the driver in terms of identifying features. He couldn't determine the driver's gender. He couldn't determine the driver's race, ethnicity, nothing about the driver. Further find that evidence then shows that the officer ran the registration of the vehicle, which he's permitted to do. There's nothing that prohibits a police officer from running random checks on a car. If the car's in public, you drive your car in public, your officers are permitted to run plates. You can go through a parking lot and just run plates for parked vehicles there. There's nothing that prohibits that from happening. The officer ran the registration and learned that the registration came back to a Stacy Reichert, who was under suspension at that time, did not have a valid license. The officer also noticed that the rear taillight of this vehicle was broken and detected this when he observed the car apply its brakes at the intersection, I think it was Nebraska and Richmond, and a white light was emitted from the right rear taillight. This is an equipment violation, and I find that the light was broken. The evidence clearly established that, video and photos, that the right light was broken. So the officer then initiates a stop, and the court finds that there are two grounds that permit this stop and make it a lawful stop. One is there's an equipment violation, and the evidence again showed that the tail light was damaged, that a white light was emitted from the rear right tail light when the brakes were applied. But even more so, he had a right to, not more so, but just as equally, I guess, he had a right to stop the vehicle to determine whether the driver was the owner of the vehicle, because he had information that the owner was under suspension, and he had the right to do that. First, there is a inference that an officer may make that the owner of the vehicle is the driver of the vehicle. There's plenty of case law within the state of Ohio that allows officers to infer that the owner is driving the vehicle. Secondly, under Kansas versus Glover, the United States Supreme Court decision in 140 Supreme Court 1183, police officers are permitted to conduct an investigative traffic stop after the police officer runs a vehicle registration, learns that the registered owner is under suspicion. That stop is reasonable under the Fourth Amendment when the police officer lacks any information negating the inference that the owner is the driver. In this case, there is no evidence that the officer had any information that the driver was not the owner. Again, the evidence established that he couldn't make any determination in that regard. Again, no information as to gender, race, ethnicity. And since there is no evidence presented negating the inference that the owner is the driver, pursuant to Kansas versus Glover, a stop is reasonable under the Fourth Amendment. At this point, the traffic stop is conducted. He has the right to request driver's information from the driver, even when he learns at that point the driver is not the owner. He determines at that point that the driver's under suspension. He knows that the passenger who's in the owner who's the passenger is also under suspension. There's no licensed valid drivers there. He makes a determination to tow the vehicle, impound and tow the vehicle. And pursuant to the policy, there's two grounds that require it. One is a traffic hazard. You can't leave the vehicle just in the middle of Richmond Road at 11 o'clock at night. Two, under 4511-203, this is a statute that prohibits or talks about negligent entrustment of a vehicle. That requires it. And while she was cited, Ms. Reichert was cited under the city ordinance, it's the same violation. So under those two provisions in the policy, impounding and towing the vehicle was required. But regardless, the policy also permitted the officer to use his discretion to tow the vehicle. So there was no issue, nothing unlawful about the officers making the decision to impound and tow the vehicle pursuant to the policy. They were required to conduct an inventory search, and that's the exception to the warrant requirement, which permitted the search of the vehicle. So based on the foregoing, the court finds that the defendant's motion to suppress evidence is without merit, and the motion is overruled. Now we have a trial scheduled for June 10th. As of today, the defendant's speedy trial will start back up, but the June 10th date is within the speedy trial time limitations. So it's the court's intention to go forward on June 10th. Now, Mr. Hinton, I think I even told you at this pretrial, if you need more time, the court will be inclined to grant a continuance, but obviously there would have to be a waiver of speedy trial. And I'm not telling you have to do that. I'm telling you, I guess, I'm not going to make you go to trial if you tell me you need more time to prepare, if you file a motion to continue with a waiver. Obviously, if you don't file that, I have to make you go forward because it has to be tried right after that date.
Okay.
So I would be inclined to grant it if you want. I'm not trying to tell you, pressuring you. We're ready to go. I know the state, I think she indicated earlier, has subpoenas already out. I just want to make sure you're advised in the record that I'm affording you more time to prepare if you need that, if you file the continuance. I'm not going to entertain it if it gets filed, just a few days before the trial date. If it's something you want to do, file it next week, and that gives state proper notice so that I'm not going to make them prepare up to the last second, then continue the trial. That would be unfair. So I'm not going to do it. But if it's something you need, I'll grant it if you need more time. I just want the record to make sure the record's clear on that.
Thank you.
Ms. Linden, is there anything for the record on your behalf?
No, Your Honor. Thank you.
Mr. Hinton, on behalf of the defense.
Nothing further, Your Honor.
Thank you.
All rise.
Ms. Wood.
Thank you, Your Honor. We're present in case State of Ohio versus Devin M. Vance, case number 24-CR-1117. The defendant is present today in court represented by attorney Corey Hinton. We are here for purposes of a change of plea to both counts in the indictment. My understanding is that the defendant intends to enter a plea of no contest to the indictment. In speaking with Mr. Geigerich, my understanding is that there's no agreement on sentencing at this time. Thank you.
Thank you. Give me 1 second, please. All right, sorry about that. Mr. Hinton, is the prosecutor's recitation, your discussions on what you're going to do here today accurate?
Yes, Your Honor.
Ms. Vance, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here at this time?
Yes, sir.
She indicated to the court she believes that your desire to withdraw your previously entered plea of not guilty and enter a plea of no contest to the two charges in this indictment, assuming the court accepts that plea, we would then defer sentencing to a later day, get some evaluations completed, and come back on a future day where there's no agreement between the parties for any recommendations. Each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and what you're pleading no contest to, the rights you have that you give up by pleading no contest, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
Okay. And through this plea, I may accidentally say you're pleading guilty. I know you're pleading no contest, no contest pleas are rare, so I don't say that often. So I may mistakenly say no contest. Correct me if I'm guilty. Correct me if I'm wrong. This is clearly a no contest plea. You're not pleading guilty. You're pleading no contest. I know I'm going to say that at some point. All right. Okay.
Thank you.
All right. All right. Let's get started then. How old are you?
I am 41.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
You have to speak up a little bit, please.
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Oh, yes, I'm on heart medication
Okay.
and blood pressure.
Okay, hang on one second.
I'm on 9 different medications
What are those for? I mean, heart, you said heart, blood pressure.
for my heart. I have a very rare heart condition.
What are the medications for? Just all your heart?
Yeah.
Okay.
I'm on a trial study through the UH hospital.
Okay. So the medication you're on is heart medication, any other types for any other conditions?
I'm on anxiety medication
Okay.
and nightmares. For nightmares. Rotatestin.
Did you say blood pressure as well?
Yes, sir.
So what I wrote here then, I added to this form, it says I have not taken any drugs or alcohol in a 48-hour period preceding this hearing, except for medications for heart, blood pressure, anxiety, and nightmares. Is that accurate?
Yes, sir.
Okay. Any of those medications that you take for those conditions, do any of those affect your ability to understand or appreciate where you are, what's going on around you, to communicate, anything like that?
No, sir.
All right. So you're not under the influence of any of those medications right now in a negative way, which is impacting your ability to appreciate your surroundings and understand me?
No, sir.
All right. Now, you would have been served with a copy of this indictment previously. That's the document that sets forth the charges. You remember getting that?
Yes, sir.
Did you have the chance at some point to look that over?
Yes, sir.
Now, in the indictment, you're charged with 2 counts. In count 1, what's alleged here, and what you'll be pleading no contest to, is on or about September 9th, 2024 in Manor Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, a Schedule II controlled substance, and the amount of the methamphetamine equal or exceeded 5 times the bulk amount, but was less than 50 times the bulk amount. Specifically, it was 17.91 grams, which makes the offense aggravated possession of drugs a felony of the 2nd degree. Do you understand what you are charged with in pleading no contest to in count 1?
Yes, sir.
Any questions about it?
No, sir.
Can I have just a moment,
Sure.
Your Honor?
Okay.
Thank you, Your Honor.
You ready to continue?
Yes.
Sir.
In count 2, what's alleged here and what you're pleading no contest to is on or about September 9th, 2024 in Manor Lake County, Ohio, that you did knowingly obtain, possess, or use buprenorphine and naloxone, or any compound mixture, preparation, or substance containing buprenorphine and naloxone. They are Schedule III controlled substances. The amount of those 2 controlled substances did not equal or exceed the bulk amount, but it also alleged.
May I have another moment, Your Honor? Okay, thank you, Your Honor.
Now, it's alleged that the drugs involved in count 2 are less than the bulk amount, but it's also alleged you have previously been convicted of a drug abuse offense that was here in the Lake County Court of Common Pleas on February 25th of 2019, which makes the offense possession of drugs a felony of the 5th degree. Do you understand what you're charged with in pleading no contest to in count 2?
Yes, sir.
Any questions about that?
No, sir.
Do you understand the nature of the 2 charges you're pleading no contest to?
I'm sorry?
Do you understand these charges?
Yes, sir.
Well, before I can accept your plea, then I need to make sure you understand all the rights you're giving up by pleading no contest. And you, first of all, have the right to have a trial in this case. And that trial could be to me as a judge, or I listen to the evidence and I make the ultimate decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. You understand that?
Yes, sir.
You understand by pleading no contest you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, is able to present enough evidence to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since it's a criminal case, the burden is called proof beyond a reasonable doubt. It's the highest burden we have in our justice system. What it means is the amount of the evidence and the quality of that evidence the state would have to present at the trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these two charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, sir.
You understand by pleading no contest you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would be permitted on your behalf to ask those same person's questions, and that's called cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
You understand by pleading no contest you're giving up your right to cross-examine or confront these witnesses that will come in here and testify against you?
Yes, sir.
Now, you also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you and you alone would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then, that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
On this, I'm switching gears. But on this computation chart, under the maximum term, it says 3 to 12 years. I don't know what that is.
The 3 is if 2 years was imposed, the range would be 2 to 3. And then if 8 years, it would be 8 to 12.
Okay.
But we'll cross that out.
It's very confusing. Yeah. The SB term is an additional 1 to 4 years, right?
Pardon?
The SB term is additional 1 to 4 years.
Yes, I agree.
All right. Lastly, if we were to go to trial and you were found guilty, you would have the right to appeal that guilty finding. Now, by pleading no contest, you are still preserving your right to appeal any decisions this court has made up to this time, in particular the suppression ruling, that, the ruling on the suppression motion that I filed. So a plea of no contest preserves your right to appeal any decisions that I've made on issues that you've raised up to this point. You understand that?
Yes, sir.
Now, what you're not permitted to appeal, though, is that any issues that you haven't raised, by entering this plea, you're not going to be able to raise them later. You understand that? If there's any issues or challenges that you wanted to make, they had to be made by this point. Any that were, you have the right to appeal those decisions. If you didn't, any that weren't, you don't have the right to do that. You understand that by entering this plea?
Yes, sir.
Okay. All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions
No, sir.
from me?
No,
You understand them all?
Yes, sir.
And do you still want to plead no contest?
Yes, sir.
Now, a no contest plea, it's not an admission of your guilt, but it is an admission of the truth of the facts that are alleged in those 2 counts of the indictment that I read to you. And the plea or the admission of no contest cannot be used against you in any subsequent civil or criminal proceeding. You understand that?
Yes, sir.
Now, by entering a plea of no contest, I will then ask the prosecutor to recite for me what she believes the facts would show if we had a trial. If based on that recitation of the facts, you're not contesting those facts by pleading no contest, and if I find those facts are sufficient to establish what is alleged in counts 1 and 2, I would then find you guilty of those 2 charges. You understand that?
Yes, sir.
Now, if you are found guilty, the effect of that plea then is that you are ultimately will be sentenced in this case as a result of that. Do you understand that? That's not going to happen today. We get some reports and evaluations completed. But if found guilty based on the state's recitation of facts, you would at a later date be sentenced as a result of that. Do you understand that?
Yes, sir.
Now, as far as potential penalties go, count 1, you're pleading guilty, no contest to, is a felony of the 2nd degree. This offense carries with it a mandatory prison term of a minimum of, it's an indefinite prison term, so that means there's going to be a minimum and a maximum imposed. The minimum sentence will be selected from a range of 2 to 8 years. The maximum is then determined by a mathematical formula. Whatever the minimum is, you take half of that minimum sentence, you add it to the minimum, and that becomes the maximum. So for example, if I select 2 years as the minimum sentence, half of that is 1. I'd add that to the 2, and your maximum is 3 years. So it would be an indefinite prison term of 2 to 3 years. And I'm just going to give a few examples so you understand how it works. If I selected 6 to be the minimum sentence, half of that is 3. You'd add the 3 to the 6, and your maximum is 9 years. So it would be an indefinite prison term of 6 to 9 years. The maximum sentence I could impose if I selected 8 years as the minimum, half of that is 4. You'd add the 4 to the 8, and your maximum becomes 12. So it would be an indefinite prison term of minimum of 8 years, maximum of 12 years. You understand that? How that works? I select a minimum sentence in the range of 2 to 8. The maximum sentence is based on the mathematical formula I explained.
Okay, yes.
I'm just giving you different examples. I'm required to make sure you understand what the maximum sentence that you face is. So for count 1, the maximum sentence that you face is an indefinite prison term of 8 to 12 years. Do you understand that?
Yes, sir. That's the max, right?
I'm sorry?
That's the max.
She asked if that was the
That's the max. I'm required to make sure you understand the max. That doesn't mean what's happening. I just need to make sure you understand that.
Yes, sir.
And it's a mandatory prison term that has to be imposed in count 1. You understand that? Meaning you're not eligible for probation in count 1.
Yes, sir.
Now, count 2 is a felony of the 5th degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, since there are 2 separate charges here, at the time of sentencing, I had the discretion to run the prison terms in each count concurrent or consecutive to each other. Concurrent means you serve them at the same time, together at the same time. Consecutive means one after the other. You'd serve whatever the prison term was on count 2 first, finish that, then you'd serve the indefinite prison term on count 1. Do you understand that?
Yes, sir.
So in this case, if I gave you the maximum sentence on each count and ran them consecutive, you're looking at a maximum prison, indefinite prison term of a minimum of 9 years, maximum of 13 years. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole, post-release control to any other courts or agencies?
No, Your Honor, I completed my parole.
Okay. Do you have any other charges pending against you anywhere?
No, sir.
Okay. As I indicated, a prison term is mandatory, and upon your release from prison, you would be placed on what is called post-release control. It's mandatory in this case for at least 18 months, and it could be up to 3 years. That's up for the parole authority to decide exactly how long, but it has to be at least 18 months, and it could be up to 3 years. You understand that?
Yes, sir.
And when on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, going back to that indefinite prison sentence in count 1 that I explained to you before, I did tell you again it was an indefinite term, which means there's going to be a minimum sentence imposed and a maximum sentence imposed. In regards to that minimum sentence, there is a presumption that you will be released after you've served that minimum sentence in that range of 2 to 8 years, whichever number I pick. There's a presumption you'd have to be released at the end of that minimum sentence. Now, that presumption can be overcome by the prison officials if they determine that while you are in prison, you're not following the rules, basically. You're engaging in bad behavior. If you commit violations of the institution, if you're not sufficiently rehabilitated, if you pose a threat to the community, they can have a hearing. And you would be at that hearing. And if at that hearing it's determined that they prove whatever it is they're alleging regarding your committing violations or being a threat or not being rehabilitated, they can not release you after the minimum sentence. They would then pick a new date for you to be released, and there'd be a presumption that you get released on that new date. Now, again, that same presumption could be overcome if you engage in bad behavior, continue to be a threat, not be rehabilitated. Under no circumstances, however, can they keep you in beyond the maximum sentence. So hypothetically, if you were just there and you misbehaved the entire time you were there, they have to release you at the end of the maximum sentence. Do you understand that?
Yes, sir.
Now, also in regards to the sentence in count 1, it's a mandatory prison term that must be imposed. That means that you will not be able to earn good time credit towards a reduction in your minimum sentence. Do you understand that?
So I can't get good time credit?
No, you're not entitled to good time, to the prison credit you're not entitled to that. And you're not entitled to apply for judicial release when it's a mandatory prison sentence. Do you understand that?
Yes, sir.
Now, in addition to the prison term I've just explained to you, there's other sanctions that can and will be imposed. You could be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
There's also a mandatory fine that's required to be imposed for count 1 of at least $7,500, and you could be fined up to $15,000. You understand that?
Yes, sir.
Now, your lawyer can file what's called an affidavit of indigency if you are indigent, and I can take that into consideration, and they have the discretion to waive that fine if I find you're indigent, but I have to impose it unless I have that affidavit to consider. Do you understand that?
Yes, sir.
Now, on count 2, there's a possible fine of up to $2,500. That one's not mandatory, but I could fine you up to that amount for that count. Do you understand that?
Yes, sir.
So altogether, there's a maximum possible fine of $17,500 that could be ordered. Do you understand that?
Yes, sir.
I could also order that your license be suspended for up to 5 years. That's not mandatory or required, but I have the discretion to do that. Do you understand that?
Yes, sir.
And that's it. Now, a few moments ago, I explained the prison term you face, and again, I told you it was mandatory, which means, again, that you are not eligible in this case for community control sanctions, which we sometimes call probation. You understand that?
Yes, sir.
You understand that I'll have to impose a prison sentence in this case. You understand that?
Yes, sir.
Lastly, when we do proceed to the sentencing hearing, you're going to have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face at sentencing and what can happen at the time of sentencing?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead no contest?
Yes, sir.
Have you had enough time to go over everything here with your lawyer?
Yes, sir.
Has he or has anyone made any promises to you about what's going to happen at sentencing which is inducing you to plead no contest?
No, sir.
Have you been threatened or coerced by anyone to plead no contest?
No, sir.
Are you entering this plea here freely and voluntarily? Is this what you want to do?
Yes, sir.
All right, then. Do you have any questions for me at this point before we go forward with your actual plea regarding anything we've talked about?
Why didn't I get a plea deal?
Well, that was explained, quite frankly, on the record at the suppression hearing. You chose to go forward with the suppression motion, and
Okay.
the state indicated if there was going to be any plea deals, it was going to be off if you went forward. But I'm not involved in that. That's between the parties. But that was put on the record,
Okay.
and that's the only reason I'm commenting on it, because that was on the record at the time of the suppression hearing.
Yes, sir.
And you made that choice.
Okay.
Any other questions regarding anything we've talked about?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, sir.
All right, then what's going to happen at this point? The prosecutor is going to explain for me what she believes the facts would establish in counts 1 and 2. I want you to listen to her because I'm going to have a question for you about that. So, Ms. Wood?
Thank you, Your Honor. If this case proceeded to trial, the evidence would have shown that on September 9th, 2024, in the city of Mentor Lake County, Ohio, officers observed the defendant's vehicle commit traffic violations and, as a result, conducted a traffic stop on the vehicle. The driver was the defendant, Devin Vance, and her passenger had a warrant out. The officer observed her moving items and hiding them in the car. When asked about it, she stated it was just a scale. A digital scale with methamphetamine residue was recovered from behind the front passenger seat inside the vehicle. They also searched the defendant's purse, which officers located a glass smoking pipe with suspected methamphetamine residue as well. The defendant was searched. Inside of her bra, officers located a baggie containing methamphetamine, $160 in U.S. currency, and 3 prescription pills with an imprint of AN415, as well as her Samsung Galaxy cell phone. She was read her Miranda rights and stated that she had just picked up the methamphetamine in Cleveland and was taking it to someone who was staying at a nearby hotel. The drugs were tested by the Lake County Crime Lab and were identified as containing 17.77 grams of methamphetamine, a Schedule II controlled substance. The tablets contained 3 unit doses, 1.21 grams of buprenorphine and naloxone, a Schedule III controlled substance. The defendant does have a prior conviction for a drug abuse offense in this court from February 25th, 2019, case number 18-CR1132, and that conviction was for aggravated trafficking in drugs, a felony of the 3rd degree. Thank you.
So, Ms. Vance, were you able to hear what the prosecutor just had to say regarding what she believes the facts would establish if we had a trial?
Yes, sir.
And as to those facts, how do you plea at this time?
No contest.
Very well. The court finds, based on the state's recitation of the facts, that those facts that do support a basis for a violation, the violations that are alleged in both counts 1 and 2. Accordingly, I find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 2nd degree, and count 2, possession of drugs, a felony of the 5th degree. Ms. Vance, at this time I have in my possession a written document, 6 pages, which set forth everything we've just gone over. The rights you're giving up, the penalties you face, what you're pleading no contest to. Before I can accept the plea, I need to make sure you understand the document, they signed it here in court. Now, my understanding is you had a chance to go over this with your lawyer before I walked out here, is that right?
Yes, sir.
Mr. Hinton, is that accurate? Did you review this with your client?
Yes, Your Honor.
Answer all her questions?
Yes.
Did she indicate an understanding of it to you when you did that?
Yes.
Ms. Vance, is that accurate?
Yes, sir.
So you understand what the document says?
Yes, sir.
And you went over it with your lawyer?
Yes, sir.
Do you have any questions for me about it?
No, sir.
Now, it appears that you signed it here in a couple spots. Did you sign it in both spots, the last 2 pages?
I signed, yeah.
Sorry?
I signed, yes.
Okay. Mr. Hinton, you witnessed those signatures?
Yes.
Ms. Wood, you as well?
Yes, Your Honor.
Very well, then, at this time, again, based on the state's recitation of the facts, the defendant's plea of no contest, court will accept the defendant's plea. Hang on 1 second. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the no contest plea, as well as all the rights she is giving up. Based upon that, and again, the recitation of the facts, the court hereby accepts the plea and finds the defendant guilty of count 1, aggravated possession of drugs, a felony of 2nd degree, violation of 292511 of the revised code, as well as count 2, possession of drugs, a felony of 5th degree, in violation of 292511 of the revised code, a felony of the 5th degree. At this time, I will defer sentencing, order pre-sentence report and investigation, and the bond remains revoked. Is there anything else for the record, Ms. Wood?
No, Your Honor, thank you.
Mr. Hinton?
No, Your Honor.
Thank you.
All rise.